Hello everyone. So today I will be talking about a very interesting topic, that is the process to compel the appearance and production of things before a court in investigation or any other process. So the first thing is uh, s- we have to understand what is crime. So something which violates penal law and is a positive or negative act or omission is called a crime. So crime is constituted when an evil mind thinks of doing something even when that is against the laws of the country. So the concept of crime is as ancient as the human race. So, and it has even grown to a far extent now. Crime can also be divided into the following things, that like cognizable and non-cognizable, bailable and non-bailable, compoundable and non-compoundable. So enough about crime. Now we will be talking about what is the process, what are the different options uh, to compel the appearance of a person in an investigation. So the the basic requirement for the progress of the trial in crime is the appearance of the accused. So it has been defined under chapter 6 of the Criminal Procedure Code. So the first option that we have is summons. So, the most basic and mildest form of the process is the summons, which may be issued in order to make a document or a thing appear. So, summons are issued in duplicate. So, under the seal of the court, that is required to be conveyed by the police officer of the court or any public servant to someone personally, means to the person against which the summons is issued. So what does a summons include? So summons include the clear and specific title of the suit and place, and includes date and time whenever a search appearance of a person or a thing is required. So, it will also include a brief description of the charged offences uh, against the accused. So, the power to issue summons in the hands of the police, which directs a person to be present for some investigations. So, that is the power of summons. So, whenever corporation services are to be served, a summons is presented to the secretary or principal officer of the corporation, addressed to the chief officer of the company. So, whenever it happens that a person summoned on a specific day and the person does not appear, the person's family male member are served the summons again, who is required to sign the receipt whenever the person is found. But in cases where summons cannot be served according to the above mentioned procedure, uh, the person serving the summons shall appoint one of the summonses to be a part of the house. So, this is one procedure for asking an appearance of an accused in the court. So the other one is warrant. So whenever a person fails to appear before the court on the said date after the issue of summons, he may be issued a warrant of arrest directly. So unless and until the court which issues such warrant uh, cancels it, or unless the warrant has been executed, the warrant of arrest shall remain in force. So, what are the essential requirements of a valid warrant? So, the warrant should be in prescribed form and in writing. It should include the name and designation of the person who is executing it. It must provide the full name and description of the person to be arrested. It also the next point is it must include the offences that are charged against the person to whom the warrant is issued. It must be sealed and it must be signed by the officer of the court. So a bailable warrant may be issued to a person where there is the involvement of offence related to a minor case. A warrant should always be directed to the person in charge of the police station. So it can also be directed by the court if there is surety and security by a person that his attendance may be taken and he may be released on bail. Such warrants are called bailable warrants. So uh, now the next is the process, the option to compel the production of things. So for the purpose of investigation and prosecution, the process of comparing the production of documents or a thing is necessary. So uh, 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 it is basically because unless and until the document or a thing that is required to be presented before the court is presented, uh, the trial may be delayed. So it may be an important piece of an evidence for a trial. So whenever a requirement is there by the court or any officer in charge of the police station of the production of any document of thing that is necessary for the investigation, trial, inquiry, or any other proceedings of the court, then someone may be issued or written order by an officer may be directed towards a person in whose possession the document writing lies. So the this process requires him to be present with the document or produced it any which ways. So this section which deals with the process to compel the production of things is void. So, but the discretion has to be exercised very cautiously and judiciously. So, these so today we have learned about summons, warrants, and what is the procedure or the process adopted by the court if it wants someone to produce a document or a thing to the court that is essential for a trial. So I hope this topic was interesting, guys. Leave comments about it. Thank you.